Further hearing in Newfield, Commissioner of Police and Metropolis and DSD and another.
Lord Panic.
Lords and my lady, good morning. Mr. Eadie has generously agreed I can have another 10 minutes or so. I was seeking yesterday to develop the submission that in the context of ill treatment by persons other than an agent of the state,
Yes.
Article 3 does require the state to have laws which address the wrongdoing. It does require that we have a system for deterring, investigating and prosecuting serious crime. And the question for the court is how much further Article 3 goes in imposing duties as to the manner in which the investigation is conducted. And I've accepted there must not be a refusal to conduct an investigation at all. The investigation must be conducted in good faith, as the court said in the Sazula case that the court saw at Volume 5, Tab 34. And there must not be what the court described as culpable disregard, which we say is a high test, and it's certainly much higher than an assessment of whether the investigation was conducted effectively. And I've also accepted that the Grand Chamber decisions impose higher standards, stricter standards, where the interests of children are involved, because the state has particular substantive responsibilities under Article 3. My Lords, my Lady, I also accept that Ms Kaufman and those supporting her will be able to show the court many decisions of sections of the court which go further. But the case law is confused because some of those cases involve wrongful conduct by state agents, some of them involve deficient laws, and some of them involve the state knowing or having reason to know of a specific danger to a specific victim. What none of the cases address is the point that the strength of the Article 3 obligation is tempered by the public policy concerns that a broader investigative duty, a stricter investigative duty, would impede the effectiveness of investigations by the police. There's no assessment of that issue, as far as we can see, in any of the cases. And the court knows that the European Court does have regard to public policy concerns in the context of policing. See Osman on Article 2 at paragraph 116. The court saw it yesterday. I won't go back to it unless invited to do so. It was volume 4, tab 32, page 1382. And our case is that having regard to the public policy concerns expressed at the highest judicial level, having regard to the other remedies available to the respondents, the damages claim against the wrongdoer, a factor which the Grand Chamber itself considered highly material under Article 2. The court will recall the Calvelli case, Volume 3, Tab 20. These respondents have received compensation from the wrongdoer, War Boys. Compensation under the Criminal Injuries Compensation Scheme, which again applied in this case. The police disciplinary regime, which operated here. And having regard to the fact, we say, there was here a good faith investigation. It certainly involved many errors and failures, but we say it did not reach the level of there being no investigation at all, or indeed culpable disregard. And for those reasons, we invite the court to say that there was no breach of Article 3 on the facts of this case, or at the very least to state the principle, making it clear for future cases that mere lack of effectiveness in investigation does not establish a breach of Article 3. At Grand Chamber level, we say there is no clear and consistent line of authorities to the contrary, to our submissions. And if the appeal were to be allowed, then of course it would be open to the respondents to take the matter to Strasbourg. Strasbourg can decide. Those, my lords and my lady, are the submissions for the Commissioner.
Thank you, Lord Panic. Mr. Johnson. Mr. Eadie.
My lords, my lady, the Secretary of State intervenes in this appeal because she is concerned. She is concerned because she shares the analysis and conclusions reached by the House of Lords and by this court on the public interests that are in play and how they should be balanced with the private interests that are in play in this sort of case. That is, in the context of actions for damages based on police investigations into criminal acts by private individuals, which are said to involve the entire range of Article 2 and Article 3, and which are said not to have met the reasonableness standard. And she is concerned also because that conclusion, I submit on her behalf, should not be overturned without the most careful scrutiny, without direct consideration of those public interest factors and how they might play into the nature of any investigative duty, and without a reasoned explanation as to why it is that the European Convention on Human Rights impliedly, and it is impliedly, compels a different answer. And I start, therefore, with the public interest, which I can take very quickly because my learned friend Lord Panic has gone through, and I'm not going to go back through the cases in detail. 3 matters only emerging from that case law in relation to the public interest.
Yep.
First, this is not a situation in which there is a single isolated judgment. There is, if you want to draw the phrase from the Strasbourg analysis, a clear and consistent line of authority domestically and at the very highest level, with analysis and conclusions that are of direct relevance to the issues that we're considering about the shape of the public interest. That analysis and those conclusions have been repeatedly subjected to stress testing and to rigorous challenge in cases of real forensic merit. And the public interest considerations have survived at their core. Hill, Bundle 1, Tab 2. Calverley, Brooks, Smith, Michael, all at the very highest level. That's the first point. The second point is that on the public interest, there are a number of consistent strands of principle emerging from that line of high authority. There is real concern that to impose a reasonableness duty, a duty of care of a general kind on police in relation to their investigations, might lead to defensive policing and defensive investigations. There is concern about police priorities being affected by the risk of being sued. There is concern about the inevitable and serious diversion of resources created by the time needed to reopen and re-examine past investigations to defend against such claims, flowing from the manpower that would need to be diverted to the preparation of witness statements and to the conduct of trials. There is concern about the payments of compensation and the costs themselves that would have to come from the police budget, with the inevitable resource balancing considerations pointed out by Lord Toulson at paragraph 122 of Michael.
We are very, very familiar
You
with
are,
these
my lady.
concerns. Most of us have read all the cases more than once.
Well,
What I would be interested in knowing, because we did discuss it in 1 or 2 cases of a similar nature, is what evidence there is to support these concerns.
well, my lady, if one goes back to those cases, I think I'm right in saying that in none of them was there, as it were, a full-blown dispute on the evidence or indeed any evidence put in about those matters. They were taken as being self-evident and obvious And that isn't.
They were considerably debated in Michael.
They were considerably debated, but I think there were, I don't think on the basis of affidavits, were there, or witness statements.
I'm still asking, what's the evidence to support the concerns? Because we're talking here about a restriction on what might otherwise be the duty of care owed. And other restrictions, which have been supported by very similar concerns, have been whittled away. Take the obvious example, the liability of barristers for what they do.
Rondell and Worsley line.
Yes,
My
exactly.
lady, of course.
And one of the reasons for that whittling away, quite apart from consistency with other areas of the law, was the lack of any evidence that barristers would become less effective if they ran the risk of being...
My lady, I think the true answer to my lady's question is I haven't seen in any of the reports of those earlier cases any reference to witness statements or in the earlier cases affidavits, one way or t'other about
no evidence.
Well, my lady puts it to me on the basis of no evidence. No evidence, yes, but no evidence not leading to the superior courts and the majority in those superior courts concluding that the public interest factors were real and were in play and overtopped the private interests that might otherwise flow from the ability to sue. And so no evidence not leading to the punchline, therefore there is no justification on fair, just and reasonable grounds for, as it were, declining to impose a duty of care on police. So I accept the factual premise on which my lady is put, but my response is no evidence in any of those cases either, and appears to have been treated by the House of Lords and by the Supreme Court repeatedly as being self-evident, as being conclusions that can properly be reached on the public interest by the courts without the need for specific evidence.
I don't think Lord Toulson in Michael accepted that the range of public policy considerations in cases such as Hill were still applicable. But leave that aside. Of their natures, I put to Lord Pannick yesterday, public policy considerations are not set in stone, cannot be. With unfolding knowledge, with a better appreciation of the circumstances which underlie the public policy considerations, simply because earlier courts have said this is their perception of the public policy imperative, it doesn't mean that those are necessarily binding on this court.
My Lord, I accept that up to a degree, if I may. I accept, of course, that as
on my part,
I accept that, of course, as a general proposition, because it is no more than the common law reflection of what Strasbourg calls the living instrument doctrine. However, domestic law does have rules of precedent. It does look to the wisdom of past cases to inform the disposition of present cases. And my Lord's points would be good points, if I may respectfully say so, if what you had was perhaps Hill alone and nothing since then, or even something earlier than Hill and nothing since then. But you haven't got that. What you've actually got in very recent times, including most recently in 2015, is repeated consideration of exactly the same set of issues. What public interests are in play here? And repeatedly the same conclusion by the majorities in those cases. And repeated conclusions, I emphasise, that were stress tested against much more difficult circumstances than the nature of the duty that is imposed, that is sought to be imposed by the respondents in this appeal. Because the difficult issues in those cases, a difficulty that led Lord Bingham to dissent in Smith, and that led my Lord and my Lady to dissent in Michael on the facts. The difficult cases were the ones which effectively mirrored Osman. They were the mirror of Osman type cases. They caused the difficulty. It wasn't a question about general duties, but my point is a more general one, which is that the public interests, it cannot sensibly be said that the public interests that are in play here can be discounted on the basis that they were expressed in rather different language in various different cases, and or that the public interest has in some way, shape or form moved on since the matter was last stress tested in 2015 by this very court.
Well, just taking the category that the categorization that you gave us a moment ago, some of the aspects, risk of suits, time and resources diverted, payments of compensation, were unequivocally accepted by Lord Toulson in paragraph 122 of his judgment.
121 and 122.
And one can accept that, though it would be interesting to have some statistics. I mean, everybody knows that medical negligence claims consume a lot of time and costs compared with systems like the New Zealand, which have automatic compensation system and no negligence claims. Yeah. Can I just ask another question? On top of that, if we recognise in this type of situation a duty, a substantive duty, which for ease of reference I call a duty to have an appropriate system, and if there's a breach of it, then presumably, or I mean if there's an arguable breach, a possible breach, presumably in taking this case, there would then be a duty under Articles 2 and 3 to investigate whether there had been a breach of the substantive duty. There would be a parasitical investigative duty to investigate whether the investigation of the first instance in this case had been appropriate. Because that sort of parasitical duty follows, doesn't it, from Article 2-3 duties?
Some sort of parasitic duty follows.
Yes, so
it might be thought that the true issue in this case was not is there a duty at all, whatever adjective you choose to put on it, of the investigative kind, yes, but what is the nature of it? My learned friend Lord Panic this morning has accepted, and we have always accepted, that there is a duty to have a system of laws. You can't just sit on your hands and have the laws passed and not do anything about it, and the other side accept that it's not mere casual error or isolated omission, however it's put.
Well, I think that, I mean, if it boils down to that, that is a really difficult question because, I mean, you tend to look at it in qualitative terms, I understand, or at least that's what I understood from what Lord Panic said and what you said. But it may be that the distinction is between something which is systematic and something which is isolated, isolated shortfall. But in that case, you ask, well, how far down does system go? Because I mean,
you do, and I rather suspect that may be very close to the heart of it. We put it quite structurally.
Well, I
because
think that's
as Lord,
the important point.
As I think Lord Roger pointed out all those years ago in one of the early Smith cases, you can recast almost any allegation of negligence as a failure of training and then call it systemic.
Well,
what we argue for, I'm sorry to interrupt, my lord, but something more structural.
That's expressed. I'm interested in any help you can give on.
I'm going to come to that if I may. But my fundamental submission, you will understand, is going to be, I start with the public interest conclusions. I've sought to answer some questions in relation to whether those remain valid today. My submission is they do. And what I want is the opportunity on behalf of Her Majesty's government to go to Strasbourg and ask them to consider something they have not yet considered, which is how, if they don't accept those public interest premises, well, so be it. Yes. But if they do, how does that impact on where that bar should be set? More structural, more systemic, more individual negligence?
Well, can I ask then a further question? How I mean, if we feel that we've got at least in the first instance to try and decide this instant case, how far are we not bound by the judge's use, I'm not sure of quite the terminology, but of concepts like systematic breach in relation to, for example, the first instance? He may have been putting the idea of a system
too
low. And I mean, we need some help on that.
Well, I'm not the best person to give you that because I'm not involved in the appeal.
No, right.
But my concern is that, as it were, the use of the concept of system, which Strasbourg has often linked to laws,
yes,
but the concept of using systemic in the more domestic sense, yes, risks collapsing a really serious and interesting point of distinction between what I call structures,
yes,
and errors and omissions or negligence.
Maybe you prefer to use the word structure.
I do. That's what I'm going to do.
Something. Yes, right.
That's what I'm going to do. Right. But while still on the public interest, and still on the second point, I've sought to draw out the strands, sought to answer the point that they remain real, and just to come back finally on that to the point that Lord Toulson in Michael only, as it were, approved the resources and the police priorities. In truth, he went a little bit further than that. He didn't disavow, if I can call it this, the defensive policing point, and he answered, as it were, against the appellants in that case the idea that actually to impose a duty would render police performance more efficient and better, and he rejected that. So he left at the very best for the other side open the other factors in Hill. But the key point in relation to those strands of public policy are that the conclusion of the courts in all of those cases was that the maintenance of police efficiency and effectiveness was better secured by other methods than litigation asserting that they hadn't acted reasonably. See, for example, Lord Hope in Smith at paragraph 81, citing Lord Hoffman extrajudicially, bundle 2, tab 13, page 546, and see Lord Toulson at 121 of his judgment, taking that argument about improving police efficiency and rejecting it because other mechanisms existed, disciplinary proceedings, for example, to which he could have added police complaints, public law, and so on. That's the second point. The third point is that the strength of the merits of the deserving case have been factored into that analysis and have been considered with particular care, especially so when a powerful case on proximity can be made. See, for example, the Lord Bingham dissent in Smith and the dissent by Lady Hell and Lord Kerr in Michael. But the majority in both of those cases did not consider that even in a case of such proximity, a duty should be owed. And the reason for that was because the public interest won out. And it did so based on what was repeatedly described as the core principle in Hill, namely the strands that I've identified. And the majority view represents the current state of domestic law. At base, that majority view recognises the need to weigh the private interest against the general interests of the community. And that's almost exactly the phraseology used by Lord Steyn in El Ghazuli Daff, cited by Lord Hope in Smith at para 74, and it is a balance not unfamiliar to the European Court of Human Rights. And the general interest wins out because if the factors that I've just mentioned, the strands of the core principle, are correct, as this House, as the House of Lords and this court concluded they were, there are serious risks that allowing private suit would come at greater cost to the general interests of the community. As it was put by Lord Steyn in Brooks, recited by Lord Toulson in Michael at para 48, by placing general duties of care on the police to victims, the police's ability to perform their public functions in the interests of the community fearlessly and with dispatch would be impeded. So the conclusion is that for all the reasons analysed with such care in those cases, the imposition of a reasonable care general duty would be likely positively to harm the effectiveness and efficiency of police efforts to perform their core public functions. That's the domestic position. The European Court position, the ECHR position, if I can turn to that, and the core point perhaps is this: the relevance of the public interest analysis of the House of Lords and Supreme Court is, it might be thought, that it cuts directly and fundamentally across the heart of the justification for implying a duty of the kind asserted by the respondents. There is no express duty in Article 3 to investigate. It is implied on the basis and only on the basis that it is necessary or justified to imply such a duty in order to avoid the effectiveness of the express guarantee being undermined. And it's to be noted in parenthesis, perhaps, that here we're dealing with an extension being built on an implication in the present context, because there is no express duty on anyone other than agents of the state not to commit the primary ill treatment under Article 3. But the core point here is that the foundation for implication of investigative duty can only be to render effective and practical ECHR protection for one citizen against ill treatment by another citizen under Article 3, criminality, protection, if you will, for Jacqueline Hill from Peter Sutcliffe. Yet the essence of the reasoning of the House of Lords and the Supreme Court is that the result of the imposition of such a duty would be likely positively to impede the efficient and effective performance of the range of police functions. And overall, therefore, the result would be to the detriment, not to the advancement of those protective functions. And so if the analysis of the public interest in those cases domestically is correct, the general interest of the community is positively served by the non-imposition of such a duty, i.e. a general duty based on reasonable steps alone. And where then, it might be asked, is the principal justification for the implication of a duty of that nature? That's the big point in terms of principle. As to the run of cases in Strasbourg, two key points perhaps can be made with respect to the Strasbourg court. The first is that the Michael line, if I can call it that, and its consistent and clear analysis of the public interest factors in play has never been addressed. It has never been argued before the European Court at all, as far as one can tell, let alone in the Grand Chamber. And so the true position is that we simply do not know how Argenteratum would locute, because they've never been asked the question, and they've evidently never turned their minds to the points. And secondly, it might be thought with respect to them that the case law is at least tolerably muddled. It does not clearly establish that a duty under Article 3 in the private context is either A, generally owed, so as to cut across all the proximity thinking in the domestic case law, or B, is simply in the nature of a reasonable steps duty. So that's the nature of the decision-making that has happened in Strasbourg and that is of interest for this court when considering whether further dialogue is of interest. Three short points on the line of jurisprudence that you've been taken to. The first is that the line stemming from MC, on which the respondents rely, is, at least if it is taken to be supportive, of a duty of that kind. In other words, a generally owed duty in investigations based simply on reasonable steps as the quality of the duty. If that is the assertion, this line of jurisprudence is highly questionable at base. It's questionable at base because it cites, for the proposition in MC at para 151, Calvelli. Calvelli is in bundle 3, tab 20. But it might be thought that there was a rather more interesting explanation of Calvelli. Calvelli, if you recall, was one of those healthcare cases, and it is cited in MC for the proposition, it might be thought a tolerably narrow proposition, that the investigative duty under Article 3 cannot be considered in principle to be limited solely to cases of ill treatment by the state. And it might be thought that Calvelli is interesting from that perspective, but only because it is about the extent of safeguarding of life under Article 2, and because it went no further in Calvelli than identifying the need for structures, to use that word. Calvelli is all about structures. It's all about the ability to go in that case in particular, to go into civil proceedings and complain about the negligence of the doctors and on the facts they settled, and that was deemed to be thoroughly important in Calvelli. So it's interesting for its structural approach. And so if one takes MC as being, as it were, a not shut out principle rather than a positive assertion of a reasonable steps principle, Calvelli becomes interesting and non-objectionable. And so that, I think, is the answer, if I may say so, to the question that Lord Kerr put yesterday to my learned friend Lord Panic. If you leave out of account, was the question, the fact that Calvelli really isn't much to do with the investigative obligation under Article 3 at all, what's objectionable about the reasoning that the European Court deployed at 151, 152 and 153 of MC, to which our answer is, it all depends upon what that means. If that is structural, and you need laws, and you need the basic structures, and you need to demonstrate that they're being operated in good faith and so on, then there's nothing objectionable about it. If, however, that is taken as being the start of a broader principle that leads to a general duty based on reasonable steps alone, it is thoroughly objectionable for the very public interest reasons that the House of Lords and the Supreme Court have identified. So that's what we say about the base of this line of jurisprudence. Secondly, as I've already indicated, the test in the cases appears to be cast in a variety of different ways. You've seen the Zula and the United Kingdom, where it was put the emphasis on bad faith and systems being linked to laws. Sometimes they use the concept of reasonableness, but often that concept of reasonableness is linked to conduct which is pretty plainly structural, because it relates to laws or because it indicates a fundamentally inappropriate discriminatory attitude on the part of the police. And so one can't build too much on that word. But the test, what is the nature of this duty under Article 3 and how far does it extend beyond having a system of laws, is put in a whole variety of different ways. And that does raise the question of precisely where one puts that bar. And it's for that reason, I respectfully submit, because the public interests identified in our domestic case law bear directly on where that bar should be set. And if the test is cast in a variety of different ways, that is of real interest, again, on the question of dialogue. The third point on the line of jurisprudence in Strasbourg is that there is at least a real risk in relation to a future victim who asserts, for example, that they wouldn't have been attacked but for the failure of a reasonably operated earlier investigation by the perpetrator. It risks conflating two very distinct duties. I'm well aware that there are potential crossovers between these various duties, and different adjectives have been used which confuses the picture further. But at a basic level, there are two different types and distinct types of duty in play. There is what may be termed the protective duty. That's the Osman duty. And that has been cast by Strasbourg as an implied duty under 2 and 3, very carefully and very narrowly. A real and immediate risk to an identified individual of which the authorities knew or ought to have known. Cast in that way, in precise recognition of the need not to cast disproportionate burdens on the state. And it was that narrowness, if you recall, if one's looking for a bounce back into the domestic jurisprudence, it was that narrowness which attracted Lord Bingham in Smith. And I would add, but even that narrowness, in other words, even to impose a duty of care in that narrow range of circumstances where there were threats that had been made, a real and immediate risk to an identified individual of which the authorities actually knew, even that did not attract or persuade the majority of members of that court to impose the duty, and didn't attract them on both proximity grounds and because of the public interest objections to doing so. But that's one type of duty, the protective duty imposed by Strasbourg. The second is the investigative duty, the adjectival duty that arises in certain circumstances, and that's an after-the-event duty. When the ill treatment has happened, this isn't about preventing the ill treatment, this is about investigating it after it has occurred.
Yes, that is, of course, the case, except that part of the purpose of investigation is to learn lessons for the future.
Certainly.
With a view to preventing future incidents of the same sort. So it has a preventive function.
I entirely agree. There is a crossover between them. They're not, as it were, hermetically sealed or isolated, and that's why the adjectives can, to some extent, confuse, because there's a washover from one to the other in both ways. But it takes it a stage beyond, quite a long way beyond the protective nature of the duty, with its carefully formulated circumstances in which the state is obliged to protect under 2 and 3. It takes it a stage beyond that to create a right in the general public to claim damages for a failure to investigate ill treatment of an earlier victim, so none of that proximity, if you will, none of that Osman link, and then to make a causation case and simply say, well, we'll have some damages, thank you. In nature, that sort of case, if only you'd investigated it properly, I wouldn't have been attacked, that case asserts a failure to protect by not investigating properly earlier. That's the elision, that's the conflation and the blurring, which is difficult. And it's difficult because the problem it creates is that the duty in nature, if you conflate them and blur them in that way, becomes generally owed to the general public in all circumstances, not to an identified individual in identified circumstances. It therefore sidesteps the careful limitation that Strasbourg has imposed on good public interest grounds of the protective duty. And so it ignores the general interests in not creating a disproportionate or impossible set of protective burdens on the state. And it is therefore a very large leap to jump from the Strasbourg investigative duty as described to date to anything that goes even remotely this far. There is no case in Strasbourg to suggest that that type of duty or correlative right exists by implication within Articles 3 or 2. So those are three short points on that line of jurisprudence. Is there a way of reconciling them is perhaps the next thought.
Can I just, the risk of conflating two distinct duties, there's the Osman duty and then the investigative duty, how do you delimit that precisely? When does it arise?
That's what I'm going to come to on reconciliation.
Yes.
I'm going to say that the way of reconciling them is to go structural, in a nutshell. And my submission, positively, is that it is possible to read the base principle from 151 to 153 of MC and the following cases. It is possible to read that base principle and its application in a more limited way. There are perhaps two analytical stages in that reconciliation. The first is to take the initial statement in MC as not amounting to a full-blown imposition of a general duty to investigate with reasonable care in the context of crime by private individuals, and to treat it therefore as a principle, and indeed the very way in which the principle is expressed, it might be thought, is supportive of this. You treat the principle as one which doesn't shut the door, that's the second sentence of 151, rather than being one seeking to set the precise nature and content of the situations in which the door might be open.
So that relates to the first sentence in 151.
I thought the second, but I may be...
The second, no, that's all right. It's my...
Does it make more sense in relation to the second? I haven't got it
Such
open.
positive obligations cannot be considered in principle to be limited solely to cases of ill
Exactly.
treatment.
So it's a not shutting the door principle rather than a design of the nature and content of the duty principle. So you treat it in that way as being limited. We don't shut the door on that, and as it were, it is neutral on the nature of the duty. And then second, this is the second analytical stage, you then design a principle that focuses on structural protections. And the advantage of that, the attraction of that, is, it might be thought, focusing on structural protections, is that it avoids police, hopefully never in this jurisdiction, but it avoids the spectre of police simply ignoring the fact that a crime has been committed, and it avoids the laws themselves being flawed, but it also avoids the rocks of a general reasonable care duty, the rocks being the public interest considerations identified by the House of Lords and the Supreme Court. And its attraction, therefore, is that it strikes the balance in terms of the nature and content of that duty at an appropriate place in terms of the general interests of the community. It does so in private cases, if I can call them that. State agent ill treatment and the nature of the investigative duty may very well be different and may very well be more onerous, precisely because it is ill treatment by the state. And I deliberately call it structural because it is centrally about the existence of structures enabling a degree of control and effective protection without the risks of positively impeding the effectiveness of that protection. And it is that balance that identifies in principle the nature of the dividing line. And the moment you start drifting towards it being a general duty, conditioned but only by the reasonableness of the steps, you drift straight towards the rocks that are the general interest considerations identified in the domestic case law. And it isn't, therefore, something which can or should admit of a semantic answer, for precisely the reasons I was discussing with Lord Mance earlier on. You can't recharacterise allegations of failure to take reasonable steps as systemic because you didn't train hard enough to avoid the unreasonable error that occurred, because you can always do that, as the House of Lords and Supreme Court has pointed out on a number of occasions. All negligence can be recharacterised as some form of systemic failure. It just depends how far back you go. What
definition of systemic do you offer us?
I call it structural for that reason, in order to try to draw that distinction.
What does structural mean then?
Well, structural means that you have a system of laws, that you are able to demonstrate that you are not sitting on your hands, as it were. That, it might be thought, is the true emotional underpinning, if I can put it that way, of the statement of principle in Zula, to which my learned friend Lord Panic took you to yesterday. And you look to see whether there are systems that exist and are operating effectively. As systems, as
I'd like
structures.
to focus on the operating effectively part of that answer. If there can be demonstrated a failure to comply with force orders, a failure to observe good police practice, does that come within the rubric of structured?
My Lord, I submit not. It isn't just about individual policies of individual organisations on the ground, just as it wasn't in Calvelli, the base authority, just as it wasn't there. There was almost admitted, I think, negligence there by the doctor in question.
So even if there's a wholesale failure...
Well, if there was a wholesale failure, that might be different.
I mean, I'm talking about a wholesale failure on the part of the team of detectives assigned to a particular...
But then you drift towards reasonable steps. I don't accept that. No,
that doesn't come within.
It doesn't.
Systemic. Or
I respectfully submit not. I mean,
well,
I can quite see that there are difficult lines of distinction and division to be drawn. But my submission is that this is about a higher level of generality, and the principle that guides where that bar should be put is precisely the public interest principles that were identified in the Michael line of cases. The moment you drift into a place where all of those concerns about positively impeding effectiveness are in play, you're in trouble.
Well, how do you reconcile that with 153 of MC? On that basis, the court considers that states have a positive obligation inherent in Articles 3 and 8 to enact criminal law provisions effectively punishing rape, and to apply them in practice through effective investigation and prosecution.
Yeah. Well, that's my. I don't have difficulty with that second part, but there are a million questions as to what that means.
Can you just remind us of the context in which it was said? This is Bulgarian law of rape, isn't it?
It is, and the fundamental problem, as Lord Panic took you to yesterday, was that the laws themselves were up the spout in terms of consent, because it required positive reaction and struggles, as it were. But I don't mind the principle being expressed in that way, as long as that isn't elided, that second half, into, in effect, a generally owed duty to take reasonable steps. Because the moment you're there, you run into precisely the public interest concerns that are identified domestically. But my lords, my lady, we have here that higher level of structural generality. We have the alternative systems for ensuring police efficiency. That was precisely one of the grounds of reasoning of Lord Toulson in Michael. We have disciplinary proceedings against police if they fail to follow police policies of the kind that my Lord Kerr has identified. We have an effective police complaint system. We have a system of Her Majesty's Inspectorate of Constabulary doing effective inspections. We have a system of public law under which, if the police declined to investigate or took decisions on not to investigate on discriminatory grounds or something, you could go to the admin court. The circumstances in which a public law challenge would work would be narrow, but that is, in the present context, a thoroughly good thing. you have the ability to sue the tortfeasor and to claim criminal injuries compensation. Precisely the structures, without identifying the reasonableness or otherwise of the steps by the doctors, that were sufficient in Calvelli. And so we do respectfully submit that that is the answer. And if one simply looks at the Strasbourg case law, that run of Strasbourg case law, I mean, you know my initial submission on it, which is it's a bit difficult to look too hard at that Strasbourg case law for the purpose of determining the answer to a question that they haven't asked themselves. Namely, how should the public interest factors that were identified in our domestic case law, how should they operate in terms of setting the bar when considering the content and nature of the duty? But however you crack that case law, it is a very, very long way indeed, both in principle and in application, from the simple imposition of a general duty to take reasonable care. They could simply have said that. That was the nature of it. They could have said that, and they haven't done that. They're permanently looking at whether it's a state agent, then they look at whether or not there are laws that are adequate. They look to see whether there's bad faith. They look at a whole series of tests, a whole series of monikers, if you will. And they have not said, ever, this is just a straightforward general duty owed to take reasonable steps. Instead, what they've done, if one goes back, for example, to MC, and one looks from 153 to see how they actually work through the second half of that paragraph to, for example, 168, they look to see whether there are significant flaws in the application of relevant mechanisms, and they specifically shut down the idea that allegations of error or isolated omission would be sufficient. See 168. And that's a consistent theme in the case law where the state agent is not the one who commits the ill treatment. But one has that mantra, only significant flaws, not allegations of errors or isolated omissions. One has that repeated through the case law. CAS at para 77, bundle 3, tab 221, MS 854. BV and Croatia, para 151, bundle 3, tab 18, MS 782. MGC, same point, para 61, bundle 3, tab 29, MS 1224, and so on. In the Grand Chamber, Essen, Sweden, para 90, bundle 11, tab 101, MS 3742. So those are the twin limitations on the scope of the investigative duty, even on the current Strasbourg case law, without having addressed the public interest. A significance threshold. The problem has to be sufficiently important to justify a finding that the state is in violation of Article 3. Such significant flaws. And the failing must be one that contrasts in some meaningful way with the mere identification of errors and omissions. And it's for that reason, no doubt, that they were groping, as it were, for a set of principles or a description of principle of the kind that you saw in Zula. And the other point to bear in mind, perhaps, about that case law is that it places, as one sees from the cases, it places very considerable focus on in the context of private crime at least, when considering whether the system of laws is adequate, on whether or not it has in fact operated to bring to court and to conviction the perpetrator. It isn't an obligation of result, of course, but that is often treated as being critical and dispositive. In other words, if the system has operated to bring the criminal to bear and to the point of conviction, then that is quite often treated as being the end of the matter. That, it might be thought, I haven't got time to take you to them, but that, it might be thought, is the core of the reasoning in O'Keefe, the Grand Chamber decision in O'Keefe, the Irish case, para 170 to 173 at bundle 4, tab 31, MS 1290. They simply say, has the investigative duty under Article 3 been complied with? Well, might be a bit unfortunate that this, that, and the other didn't happen, but the fact is that this individual has been convicted. And you get exactly the same species of reasoning, and it is a case that is worth having a read of. In the Menson decision, one of the Article 2 cases, it was often cited as being on the boundaries between 2 and 3. But
these weren't cases where the failure of the system led to the possibility of another offence.
they weren't cases of that sort. They weren't.
I mean, that's the difficulty. I mean, a conviction can cure the particular problem to a degree where you're focusing on an offence committed and a victim of that offence. But if you're focusing on a failure to prevent another victim being, it's different.
My Lord, it is different, but can I just say in response to that, it is different, and I entirely accept that it's different, but the analysis there, it might be thought, if you don't conflate what I've called the protective duty and the investigative duty, if you don't conflate them, the answer in that sort of case is you bring the criminal to bear, that sorts the Article 3 investigative duty, because the person is convicted, and the question thereafter for the future victim of crime is whether or not they properly should have been protected against the attack that then occurred. But that's an Osmond thing, and that's been very tightly controlled by Strasbourg for good reason.
Well, that's an Osmond thing, or you accept a structural thing.
That's an Osmond thing or a structural thing.
And I mean, I'm just looking at the judge at first instance findings about systemic failure. I mean, it just occurs to me that actually it might be interesting for someone to look at them and tell us whether they really are systemic failure in your terms. I think you would say no to most of them. They are, I mean, treatment of victims with sensitivity. Well, I mean, in a sense, of course, you can inculcate that from the very top down. The Prime Minister could make a speech about it, but yes. Whether it's more a matter for the individual at the... But I suppose then you say, well, training.
Everything is training. In the end,
yes, but have you got an answer to the question as to how one defines what is systemic in your terms, or structural in your terms?
Well, I think not definitionally, as it were, no. but if one goes to get a flavour from the cases, what you see is that they look at the existence of structures that operate in certain ways, and unless there's some indication that they are
high-level structures,
absolutely.
You would say.
That's why disciplinary proceedings, complaints, inspection, public law, ability to sue the tortfeasor and get money, ability to claim criminal injuries compensation, all of that.
Well, the judge used the word systemic to answer part of my Lord's question in paragraph 13, I think.
Well, I think he uses it repeatedly.
He does, but he summarises them there.
Does he define what he means by it?
I don't think he does. I think he thinks there's a run. If only I can get into a system, I'm outside errors or isolated omissions.
Yes.
I think that's the game that is afoot in the judgment.
Yes, clearly.
And my submission is that the game that needs to be afoot is a rather more high-level one. Yes. And to some extent, this distinction, this matter about quite where one draws the line, the distinction between protective and investigative, the nature of the Osmond duty. My lady raised yesterday the Opera's case, and again, that is of obvious relevance, but one needs to be careful when reading through it to identify which duties are being dealt with where. I haven't got time to go through it, but it's obviously of some interest here. I wanted, in the couple of minutes that remain to me, I wanted to say something, however tedious and however often you've heard it from me, about our constitutional arrangements. And because some questions were asked at the beginning, what do we do if we're in doubt? You know, what do we do if... and questions were asked about Lord Brown and Alscany and how all that works. So if I may, just a couple of short points on that. Take account of, you need no reminding about. Yep. It's been considered many times in recent years, Pinnock, Chester, that whole line of cases you're very, very familiar with. But the fundamental point is that the HRA opens up the possibility and the benefits of dialogue. That is, of course, subject to the dialogue being in reality a worthwhile exercise. See prisoner voting, where the answer was not. And it brings in, if you're considering whether dialogue is a worthwhile thing, it brings in the clarity and consistency of a Strasbourg line of authority and the level at which the issue has been considered in the European Court, because that is relevant to the question, is it worth having the dialogue? If the case law is not clear and consistent, or if it hasn't been considered by the Grand Chamber, there may be all the more point in inviting them to have a think about things. And to some extent, that same underpinning sits perfectly coherently and neatly with the Horncastle line of authority. Horncastle is a set of principles that were developed where it was thought that the Strasbourg case law had reached a tolerably clear answer, but nevertheless it was an answer which cut across a set of values held dear, if I can put it this way, by domestic law.
But in Horncastle, the House of Lords, or rather, sort of spanned the House of Lords and the Supreme Court, the Supreme Court did not refrain from expressing its view, and it wasn't inhibited by the circumstance that the matter was going to be considered in Al-Khawaja and Tajiri by the Grand Chamber.
Yeah.
But here, I get a flavour from Lord Pennock and from you that really we ought to be circumspect about reaching a decision because of the desirability of stimulating this dialogue. But that doesn't sit easily with me when one addresses the positive duty on a court as a public authority not to act in a way which is incompatible with the convention right.
Lord, yes, I think
in order to keep faith with that obligation, we must address the question: is a convention right violated here?
I agree. I agree, and that is, I think, the question in a slightly differently worded form that you asked my learned friend Lord Pennock yesterday.
Scarcely differently worded at all, Mr. Reading.
And my answer to it is that, and to some extent it's a Horncastle point as well, is that you have in our present context a set of values that domestic law does indeed hold dear, namely the public interest considerations that led the House of Lords and the Supreme Court to conclude that it would be, or risk being, a positive impediment to effective public protection to impose a duty of care of a general kind. That is something which domestic law holds dear, and the question for you, in Strasbourg terms, and to bring it back to your duty as a public authority, the question for you is whether Strasbourg, in its jurisprudence, has provided a clear and consistent and coherent answer. That doesn't mean you're taking into account extraneous considerations or illegitimate constitutional matters. It simply means you're doing no more and no less than to give effect to such Strasbourg case law as can properly be viewed as being clear and consistent. That was the point that was being made by Lord Brown in Alskaney. It's the no more, no less point. And you need some caution unless it is entirely clear that Strasbourg compels a different answer to the answer that you reached on the basis of public interest considerations. You need clear Strasbourg case law in order for you to reach a different answer, and you're not compelled to a different answer by anything but that. And if it isn't clear and consistent, or if you conclude that they haven't properly thought about values that our domestic law holds dear, the right answer, domestically under the Human Rights Act, is to decide this appeal in our favour to enable us to go to Strasbourg and for them to determine what the right answer is.
And I think from my point of view, you're reflecting in your own words what I said, but it's a dissenting judgment in Smith and the Ministry of Defence, paragraph 142. The prospect of a Strasbourg court deciding X3 seems to me sufficiently striking for it to be impossible to give the question a clear answer. If it's going to the European Court's going to decide that, then it seems to me a domestic court should await clear guidance from the European Court of Human Rights to that effect.
Exactly that. Exactly that, my lord. And there's nothing constitutionally aberrant about that.
Yeah.
It isn't taking into account an extraneous consideration. It's simply applying the no more and no less principle. But the no more and no less principle requires you to identify a clear and consistent principle from Strasbourg. And in
Your
the
time
end,
is up. I won't ask you any further questions, but you'll be well aware that there is very sharp disagreement about this question, and the whole business of the mirror principle and so-called ULA principle, that has been the subject of very significant debate. But
my lord, it has.
yes,
It has, but you have my submission on it in the present context.
Yeah.
A value that domestic courts hold dear, a bit of Horncastle, and no clarity and consistency in the Strasbourg case law, a bit of ULA. Answer, back to Strasbourg it goes. And in the end, as my learned friend Lord Pennock accepted, you can have some duty, and you have some duty in the protection that laws must provide and other structures that are operated. And the question really is where one sets that bar. And what I want, if I'm allowed to want anything in this court, what I want is the ability to take your public interest analysis to Strasbourg and invite them to set the bar accordingly. And was my lady, I'm sorry I've gone a couple of minutes over, but
we started a bit late. Thank you very much. Thank you, Ms. Reedy. Ms. Biffy. Thank you.
She's allowed it.
Ms. Kaufman.
Mr. Panic didn't want to hear from me. My lords, my lady, can I just start by taking stock of where we've got to in relation to the appellants and the Secretary of State's case? Because I perceive there's been some considerable movement, certainly on the part of the appellant. The position set out in the Statement of Facts and Issues is that what is in issue in this appeal is whether or not there is an investigative obligation implied in Article 3. The case being, on the part of the appellant and the Secretary of State, as I understood it, that insofar as there is an operational investigative obligation, it only arises in an adjectival sense. That is, where the state itself has been complicit in some way in the Article 3 breach. The second issue that arose for consideration is if there is an investigative obligation that applies in respect of the acts of private individuals, is it limited to a structural duty? And I will use Mr. Eadie's terminology, structural rather than systemic duty. Now, as I understood the appellant this morning, his position has, as I say, moved to some extent because it appeared that he conceded that in relation to the acts of purely private persons, that is, acts on the part of a private person where there is no question of complicity by the state, so there is no question of a breach of the Osman duty, no question of the state itself or state agents having themselves played a part in the ill treatment. So in a purely private person case, he accepted that the state must not refuse to investigate, must not act in bad faith in the course of an investigation, and when it comes to children, he appears to have accepted there is an operational duty to investigate. Now, that is a very, very far cry from the position that the appellant took in its case before the court. It doesn't go far enough, but it's significant that the defendant, the appellant, has moved, we submit. So far as the Secretary of State is concerned, his position remains that insofar as there is an investigative obligation, it is purely structural, whatever that means, wherever the dividing line actually is. So there hasn't been the same level of movement there, but there has been, and we noted this in our objections to the court, there has been a new argument that the Secretary of State has put forward, which is new because it is premised upon there being an operational investigative obligation, hence new outside the Statement of Facts and Issues, which is premised upon there not being an operational investigative obligation. And that is that insofar as there is an operational investigative obligation in relation to the acts of private persons, a person who is not the victim of the particular crime, which is said to be the subject of the investigative obligation, cannot be a victim of any finding in respect of that investigation that it was ineffective. So let's make that concrete. In relation to DSD and NBV, what the Secretary of State means is NBV, the later victim in 2007, cannot be said to have been the victim of the failure to investigate effectively DSD's complaint of rape. Now, that argument can only arise once it is accepted that there is an operational investigative duty that arises in the first place. So as we say, it's a new argument. We object to it being raised so late in the day in the case. We still object, but I will, of course, deal with it. Now, I'm going to make 9 points. in relation to the key argument put forward by both the appellant and the Secretary of State for the Home Department, that this court should not find that there is an operational investigative obligation imposed upon the state to effectively investigate ill treatment by private individuals where there is no question of state complicity. My first point is that Strasbourg has established, as a matter of its clear and constant jurisprudence, including in the Grand Chamber, that the state is under a duty to conduct an effective criminal investigation in just those circumstances, whenever it becomes aware of a credible allegation that an individual has been subject to deliberate ill treatment by a private person, irrespective of whether the state played any part at all in that offence being perpetrated. It is not limited to children. It is of general application in relation to any ill treatment which is deliberately inflicted and which crosses the very high threshold set under Article 3 for prescribing treatment. That is, it meets the test of torture, inhuman and degrading treatment.
Are you going to come at some stage, Ms. Kaufman, to what does and doesn't?
Well, I wasn't going to,
No,
because...
I'll ask later, if I may.
Yes. I mean, the courts, your lordships will see that the courts, when they look at whether an investigative obligation has been triggered in all the cases we're going to look at, the first question they ask is the ill treatment of sufficient severity to cross that threshold?
I know that.
So that's a critical question, and it's a necessary condition that has to be crossed. Secondly, this is a positive obligation which the court has found to inhere in Article 3. It is one of a cascade of positive obligations under Article 3, which the court has identified as being necessarily implied in order to render the protection afforded effective. Now, there is no dispute between the parties that a key principle that Strasbourg applies, and has indeed applied in relation to Article 3, is that the rights conferred must be effective. And that key convention principle of effectiveness has, in the context of Article 3, long resulted in the court identifying positive obligations on the state to take positive steps to protect its citizens from ill treatment by non-state actors as well as state actors. Thirdly, the court's approach to the implication of such positive obligations under Article 3 is not unique. Rather, it is the very self-same set of positive obligations arise under all the absolute rights. Article 2, the right to life. Article 4, the right to be free from slavery, trafficking, and forced labour. And this, we submit, is not in the least surprising, given the importance of the rights at stake. These are rights which the court has repeatedly stated enshrine one of the most basic values of the democratic societies making up the Council of Europe. So the defendant and the Secretary of State, if they are to succeed, must demonstrate that not only in relation to Article 3, but also in relation to Articles 2 and 4, it is the case that there are no positive operational investigative obligations in relation to the acts of private persons, or the court should refuse to follow the Strasbourg jurisprudence to that effect. Fourthly, as Liberty in its case demonstrates, Strasbourg has found positive obligations to inhere across the spectrum of convention rights where this is necessary to render those rights effective rather than theoretical and illusory. Those positive obligations have been found, for example, to require the state to take steps to protect an individual against ill treatment by private persons going way, way back, as we'll see in one of the cases, as far back as 1983. So, for example, we will see that there can be special obligations on the state in relation to prisoners, for example, who are in a particularly vulnerable position, to put in place protective systems to ensure that prisoners are not a danger to themselves or are not subjected to risk and danger from others. Now, that is different to the Osman duty. It is a species of positive protective obligation which is imposed precisely to render the rights effective, even in relation to the ill treatment of private persons. Thus, the imposition of the positive obligation to conduct an effective investigation is simply one more example of a very well-established and principled approach. Fifth, there is no rational basis.
Aren't the prisoner cases because there is a prima facie involvement of state agents there?
No. So the duty here, so if we look at the Keenan, the duty recognised in Keenan, that was a case where the individual was at risk from his own actions. So the individual was vulnerable to self-harming, and that's how we get the Middleton duty.
Yes, I see.
So what the court then says is, what must the state do? The state is under a positive obligation not only to take an operational measure to protect that individual when there is a real and immediate risk that they should have known of. So that is an operational duty to protect against that individual's own self-inflicted acts. But there is also a duty to put in place systems, overarching systems, to protect prisoners generally against the risk they may pose to themselves. Similarly, there is a duty on the state to put in place systems to protect prisoners from the risk posed by other prisoners,
yes,
the acts of third
aren't they rather similar to Osman-type situations? Because they are essentially situations where you know that there is a particular risk and you have a particular responsibility because of your particular close relationship with someone who's in custody or indeed in detention for other reasons.
No. So in my submission, no. There is the Osman duty. The equivalent Osman duty plainly applies in a prison context. It applies in circumstances where the prison authorities know and ought to know that that particular prisoner is at risk, a real and immediate risk. That is the Osman duty. But then there is an overarching duty, which let's call it a systems duty rather than a structural duty, which is a duty to put in place systems irrespective of whether any particular individual is at known risk, but by virtue of the particular vulnerability of the group. We see in O'Keefe, there's a very similar duty, we'll come to it, but there's a very similar duty that was recognised in O'Keefe. In O'Keefe, they found there was no breach of the Osman duty in relation to the children because they had no reason to know they were at real and immediate risk. But the special vulnerability of children was such that it was necessary to impose systems to detect and protect at a general level, irrespective of whether a particular individual was at risk, because of the special vulnerability of children in that situation. But the important point is in my...
It didn't go quite that far, did it, Ms. Calvin? It was, what they said was that you can't simply let schools get on with it without any sort of supervision or control.
Yes, so they had to put in place a system for supervision and control.
The whole question is how much. Anyway, go on.
The point I'm trying to get across here is that the positive obligations that can be imposed in order to render effective the rights are multifarious. They depend upon the circumstances and particular characteristics and features of those circumstances. So where there are, for example, vulnerable children in schools, it may be that it's not enough for the state to be subject to an operational duty to protect a particular child at particular known risk. There can be further positive obligations. That's the only point I'm trying to make. I'm not trying to argue as to the content of those obligations. The critical point is that the operational investigative obligation is simply another species of the same thing. It is all these rights are implied in order to render effective the overarching duty to protect the individual against the acts of third parties. Now, coming for a moment to the duty which is recognised and accepted by the Secretary of State and the appellant, and that is the operational duty. There's no question, they say, that the operational duty to protect, that is the Osman duty, does apply and exist and is implied under Articles 2, 3, and I assume they would also accept 4. Now, that is an operational duty. It is not a structural duty. It is not a system duty. It is a duty to take particular operational steps, and as we'll see in a moment, it is such steps as are reasonable in the circumstances, that is a negligence standard, in order to protect an individual who is at known, real and immediate risk. Now, once the defendant, as the appellant and the Secretary of State, accept that referring to this cascade of duties, we have, as we'll see, the duty to put in place a system of criminal laws to prescribe ill treatment by third parties, a duty to put in place the legal enforcement machinery to render effective that system of laws, that is to suppress, prevent and penalise, and under that we have the Osman duty, an operational duty to protect a particular and identifiable individual. We have stepped well below the structure and the system which Mr. Eadie submits is the limiting principle in relation to the investigative obligation. Now, why, once one accepts an operational duty to protect, which steps right down into the territory of practical steps in the particular case, why and on what rational basis should one limit the investigative obligation to a structural duty? Because as we will see, both duties derive from the same higher level principle to render effective in practice the duty to put in place the criminal law systems and the law enforcement machinery.
But I mean, this argument renders completely irrelevant all the cases in which the Strasbourg Court has carefully delimited the categories of case where either because of Osmond-type situations or because of specific duty to protect an individual's life, for example, where they've assumed responsibility for his welfare or where they knew or ought to have known that his life was a risk, that's Osmond, there's a duty. You say you can forget all about those categories. There's just a general duty to have an effective protection of individual life. But that merges the structural duty with all the individual duties, or it makes the distinctions irrelevant.
No, my lord, there's a very, very relevant distinction between the two. So the adjectival duty, as opposed to this duty, this duty stems from the duty to prescribe deliberate ill treatment in criminal law. And hence, the investigative duty which gives effect to that requirement to prescribe must be criminal in nature. It is a criminal investigative obligation to render effective the duty to prescribe, which is itself required to prevent ill treatment by private persons. The adjectival duty could apply to deliberate ill treatment by a state agent, in which case, if the ill treatment is deliberate, then yes, you'd have to have a criminal investigation. But the adjectival duty, we know, also requires an investigation into non-criminal failings on the part of the state. So, for example, the failure to protect a prisoner who is at risk of suicide because the prison officers fail to recognise an obvious risk of suicide. They fail once the risk has been realised to act quickly enough and to prevent the death. Now, that is not criminal, but the adjectival duty requires there to be an investigation because the state must account and lessons must be learned, but it doesn't need to be criminal. The two are entirely distinct, though in some cases the nature of the wrongdoing may mean that the sort of investigation that has to be conducted is identical. That is, deliberate ill treatment, whether it be by a state agent or whether it be by a private person, must be addressed by way of a criminal investigation.
Can you give us some written schematic support for the submissions and the distinctions who've just been drawn? I mean, you've used phrases like adjectival and structural and so on. Where do we relate this to authority or to textbook exposition? Because there's a real problem of categorization in this whole area. There are so many different types of duty under Article 2 and 3, and some are adjectival and some are substantive and some are operational and some are structural or systemic. Adding further adjectives isn't particularly clarificatory.
So what we will see in all the cases that the appellant and the Secretary of State has relied upon to demonstrate that an investigative obligation only arises in complicity cases are as a matter of fact, all cases where what has been an issue has been a substantive breach on the part of the state. So Humberstone, NM, all these cases, Middleton, these are all cases where in some sense it is alleged on a credible basis that the state has failed to discharge its own substantive obligations. None of those cases are cases where it is alleged that the state has breached Article 3 because of deliberate ill treatment. They're all about failing to discharge other positive obligations that are imposed, other implied positive obligations, be that the operational Osman duty or some other such duty. Now that is the adjectival duty, and one will see in the case law that it is referred to frequently as an adjectival duty. The thread of jurisprudence that we are concerned with in this case is entirely distinct, because the duty is not adjectival in the sense that it stems from a need for the state to account for its own wrongdoing. It is a duty which is effectively substantive in nature. It is a substantive duty on the state, no different from the Osman duty. It serves precisely the same purpose. It is a substantive duty on the state to take measures to prevent ill treatment by private persons. The state can do this in two ways. So if we will look at the permeability of the Osman duty.
I'm sorry, just say that again. To prevent.
To prevent, suppress and penalise, that's the wording.
Right.
That's the wording from which the Osman duty derives, and equally it's the wording from which the investigative obligation arises. Both of them, both the operational duty to protect a particular identifiable individual.
Prevent, give it to me again.
Suppress and penalise.
Suppress and penalise.
Suppress and penalise.
Very much.
Criminal or deliberate ill treatment by private persons.
Yeah.
So the source, one has to look at the source of the duty in order to understand its difference. The source of the duty, I call it the criminal investigative obligation because it is a requirement that is imposed upon the criminal law enforcement machinery of a state, and it's imposed upon the criminal law enforcement machinery of the state precisely because it serves the higher level duty of the state to prescribe in criminal law the ill treatment and put in place effective law enforcement machinery to prevent, suppress and penalise. And that's as clear as we get as to the distinction between the two. There hasn't been a case, my lord, apart from this case and the way in which the Court of Appeal approached it, there hasn't been a case in which the court has had to confront these different duties, but different they are. And part of the problem in my submission arises from a failure to appreciate the distinction between the two, and they are fundamentally different.
So you say the adjectival duty is where the state is required to account for its own failings, and this is a substantive duty to take steps to prevent, suppress and penalise deliberate ill treatment by private individuals.
Yes.
Is that the distinction you're
That's
making?
the distinction.
Thank you.
And that's
Adjectival duty is a failure to discharge, you said, other implied positive obligations. Well, what's the difference between an implied positive obligation and a substantive duty, which is your second type of duty?
So the implied positive obligation I had in mind, for example, would be the Osman duty. That is a substantive duty, but the adjectival duty is a procedural duty to investigate that failing. Here, under the criminal investigative obligation, there is no substantive duty that the state has failed to discharge. The duty on the state is to investigate. That is the substantive duty.
Well, you've just told us that there is a duty to take steps to prevent, suppress and penalise. Now you're saying that that involves an investigation, but an investigation of what? An investigation of an allegation of crime, or, I'm sorry, ill treatment is a better word, or an investigation of a failure to take steps to prevent, suppress, etc.
So we have the high order duty, which is the duty on the state to take steps to prevent ill treatment, including ill treatment by private persons.
Yes.
Strasbourg has then said, in order to discharge that high-level duty, it is necessary for the state to proscribe such ill treatment, such deliberate ill treatment, in criminal law. That is, to make it a criminal offence, to perpetrate such offences, even if you're a private person. Mm-hmm. Thereafter, it is necessary for the state not simply to stop there at that level of structure, but also to then put in place another structure. That is the law enforcement machinery, which is going to suppress, prevent, and penalise such ill treatment. Under that duty, and in order to serve that duty, there are then the operational duties, that is, the duties to take steps in practice. One is the Osman duty, to protect an individual who is at real and immediate risk, and the second is a duty to investigate credible allegations of deliberate ill treatment by a private person. So those two duties are substantive duties, they are operational duties, they stand side by side on exactly the same level in terms of the hierarchy or the cascade of duties that arise under and are implied into Articles 2 to 4.
But if it's the same type of duty as the Osman duty, you're relying on the second type of duty. If it's the same type as the Osman duty, then distinctions between casual negligence and systemic or structural negligence become irrelevant, don't they? Because Osman requires you to bear down on the particular facts, and the state has got to do its job of protection on those facts. So if we're talking about the same type of duty as that, am I not right that distinctions between casual breaches and structural breaches are irrelevant?
That is exactly the point, my lord. There is already, the appellant accepts, and the Secretary of State accepts, a duty which is part of English law now under the Human Rights Act, which is the operational duty. Which is the protective Osman duty. That duty requires the courts to bear down on the facts, to look at what protective measures were in fact taken and to ask whether they were reasonable. That is a negligence standard which is there and built into...
I have to say, I mean, I'm unable, and it may be that matters have developed since then, but I'm unable to reconcile this scheme with the scheme as I thought it existed when I wrote the judgment in Smith against Oxfordshire coroner a long time ago, but I did think that there was European court authority for a rather different approach, in particular in Menson and the United Kingdom. But if that's all wrong, you'll have to perhaps look at it and address me on it.
I'm not understanding what it is that your lordship
as I'm not sure I was out on a limb, but at that stage it seemed clear, and Middleton suggested this as well, that there was some form of high-level general duty, one understands entirely why, to have a framework. The question, of course, being open as to how far down the framework goes, or how far down for failures in framework the state is responsible. But that's one thing. But then there were a series of categories of cases, such as Osman, such as prisoners, such as conscripts, such as savage mental health detainees, and also the case, of course, of killing by state agents, where the state was either responsible for its own agents or, by virtue of special circumstances, acquired responsibility to take certain protective measures. Now, if that scheme is wrong, then it's wrong. But at the moment, that's why I really asked for you for some authority, because it seemed to me that that was precisely the scheme which the court in Menson was adopting. It examined whether the case fell within one of the special categories, whether it fell within Osman or one of the cases where the state had assumed responsibility for a particular individual's welfare, etc., or whether it was a case of state agents. And then it said, no, it isn't, but we've got to go on and consider the general framework responsibility for having a generally efficient legal system and so on. But if that's wrong, tell me.
My lord, I'm not for a moment suggesting that's wrong. What I'm suggesting is that scheme exists, and that is in relation to, so that there are, as I have just made clear, many positive obligations imposed upon the state, as well as the simple negative obligation on its agents not to ill-treat. Now, where it itself breaches those obligations, then an investigation into its alleged breach of those obligations is required. The point I'm making is that this is an entirely separate kind of investigative obligation. It has nothing whatsoever to do with failings by the state to discharge its own substantive duties. It is itself a substantive requirement on the state which is imposed in order for it to give effect to its overriding duty to protect persons within its jurisdiction from ill treatment, even by private persons. And that is exactly the same source for the positive obligation to investigate as is the source for the positive obligation to protect, the Osman duty. Both duties derive from the same source. One is an investigative obligation, the other is an obligation to take steps to protect. And as we'll see, that obligation to take steps to protect might involve investigating. They're very permeable categories, these two. So the point I was making is that once the appellant accepts that there is an operational duty upon the state to take protective measures in respect of an individual who is at real and immediate risk of ill treatment, then the defendant has already accepted that the duty to put in place systems to protect individuals from ill treatment by private persons can include an operational duty. That is a duty on the ground. And once it accepts that, it loses any foundation to argue, but that can't be the case in relation to the investigative obligation that Strasbourg has recognised. So first I have to make good and show the court that Strasbourg has recognised this investigative obligation. And then my argument is, well, if they accept the operational duty to protect, they cannot at the same time provide a rational argument for saying the investigative obligation is somehow structural. It is an irremediably, we submit, incoherent position to do so. Secondly, and this is our point 7.
What was your point 6?
Sorry, the point 6, I'm so sorry. The point 6 was that once the defendant or the appellant accepts that there is an operational duty to protect, which derives from precisely the same overarching duty as the investigative duty, it is an incoherent position to take to seek to limit the investigative obligation to assistance duty.
That means I haven't put my 5 in the right place.
Oh, I'm sorry, maybe I got...
Because you got distracted.
Yes, I'm sorry. My 5 was that there is actually no rational basis, given the key principle of effectiveness, and the appellant has certainly not provided one, for limiting the positive obligation in relation to ill treatment by private actors to a structural duty. There just isn't a rational basis to do that. And that point is bolstered by our 6th point that I've just made. The 7th point is that the defendant, and this turns to the defendant's argument, that in fact the operational investigative obligation is parasitic upon state complicity. That is, it's this adjectival duty. There has to be state complicity. And our submission in relation to that is nowhere does the court say so at all. All the cases with which the defendant, the appellant, on which the appellant has relied upon have been cases where, in fact, as a matter of fact, there was an issue about the state itself having breached one or other of its obligations, but at no point anywhere did the court say, and that is the only situation in which the duty, there can be a duty on the state to investigate. So that brings us to the appellant's, and this is our point 8, the appellant's final...
Have you got your points put down in, are they in your case, your 8 points?
No, they're not.
Can you put them on a piece of paper?
I will do that.
Yes, thank you.
So this brings the appellants finally to their last point, which is to appeal to our common law, and in particular its alleged inconsistency with the alleged inconsistency of recognising an investigative obligation with the court's steadfast refusal to recognise the duty of care on the police. But in our submission, the absence of a cause in action in negligence does not provide any permissible basis for this court to refuse to follow Strasbourg's clear and constant jurisprudence. And this is so for a number of reasons. First, Strasbourg itself, the ultimate arbiter on the meaning of the convention, has already had an opportunity to consider common law immunity from suit as a reason not to imply positive operational obligations. It had that opportunity in Osman, it had that opportunity in Z and the UK, it had that opportunity in E and the UK, and it never at any stage showed any sign of considering that the existence of immunity from suit was a reason to limit the reach of the convention in terms of its positive obligations. Secondly, there is no rational basis to distinguish those cases which were concerned with the positive operational protective duty from the investigative duty, because both have protective and investigative components, as we will see, and in respect of both, the self-same common law immunity from suit applies for the very same public policy reasons that the appellant and Secretary of State now rely upon. It's the very same public policy arguments. Thirdly, the House of Lords and the Supreme Court has itself had two opportunities to conclude that the existence of tortious immunity from suit or an absence of a duty of care in negligence is not a reason to find that an operational obligation to protect under the convention that cuts across common law immunity from suit is a reason to find that the Strasbourg operational duty does not find its way into English law or is a reason to send the matter off to Strasbourg. On both occasions, and this is in the Van Colley case and the Michael case, not for a moment did the courts hesitate in upholding the existence, under the Human Rights Act, of the positive operational duty.
What was the first case?
Van Colley.
Van Colley, that's a Smith case,
Yeah.
and Michael. Fourthly, there is in any event no conflict. The duty under the Human Rights Act is a totally different creature in law from the common law duty of care and negligence, and they serve entirely different purposes. And we will come to the Michael and Smith case to show how this court and the House of Lords have already made that plain. Finally, in relation to the appellant's forensic point, that even if the protective obligation has been received into English law under the Human Rights Act, the investigative obligation is very different, because the investigative duty is much more broadly drawn than the Osman duty. So much more broadly drawn that in the case of the one, it cuts across the common law of negligence, but in the case of the other, it doesn't. In fact, we will show that both duties are tightly drawn, both duties take account of the need for a fair balance, and both impose standards of reasonableness which require the court to get down into a solid inquiry into the factual circumstances in which protection was not afforded or an investigation was not effectively conducted. For those reasons, this is our ninth point, and I will expand upon it, we submit there is no permissible basis for departing from the clear and constant Strasbourg case law. Strasbourg has spoken, the case is closed, there is no room for further dialogue. And finally, I will deal with the point raised by the Secretary of State in relation to whether MBV could claim in respect of the failures to investigate DSD's case effectively, and also in relation to the new point raised by Mr. Panic this morning, that if there is an investigative duty, the test is one of bad faith. And I will show that the test has been very, very clearly set out in the jurisprudence, and it has been encapsulated in the judgment of Mr. Justice Green at paragraphs 221 and 226 of his judgment, and it sets out a very clear test which does not put the standard, it does not place the standard or the threshold for finding an investigation to have been ineffective as a low standard, and he takes his guidance entirely from repeated statements in the case law. So can I start? And I have to now take the court at a galloping pace through a significant number of cases which we have to look at in order to show that the jurisprudence is clear and constant. It is well settled now in Strasbourg. It's been looked at in every section of the court and right up to the Grand Chamber. And if we can start with MC in Bulgaria.
Are they set out in your written case?
We have set them out in large part in our written case.
Is that if you're going to gallop, is that a convenient way to do it rather than going to the cases, or aren't they set out sufficiently fully?
There are some parts I really would like to get the
court. Would it be sensible to take your written case and as it were, use that at least as our reference?
Exactly.
Okay,
use that as a reference, and then I will just
okay, very well.
focus where I need to and focus where I need to answer some points on the part of the defendant.
Thank you.
So,
yeah.
So,
I mean, as I say, I don't want to unfairly to tie you to your written case, but if it's going to help the gallop, then it might be a sensible way to proceed.
Yes.
But it's up to you.
Okay, well, can we start then by looking at MC?
Yep.
Now, unquestionably, MC was a case where there was a system failure in relation to the laws or the practice by which the laws were interpreted and applied. But it was also a case where there is no question whatsoever a separate complaint was made about a failure to investigate, quite apart from the system's failure. And the only way this case can properly be understood is that the court was identifying both the duty to put in place a system of laws and a duty to apply that system effectively in practice by effective investigations in the particular case. So if we turn, first of all, to the head note, H2, paragraph page 1158.
Yep.
And we can see the complaint is 3 lines down. Only cases where the victim had actively resisted were prosecuted and the authorities had not properly investigated the events. And then at paragraph 109, again, we can see this is setting out the complaints of the applicant. She makes quite clear she's making 2 separate complaints. Again, we see that the authorities had not investigated the events of the 31st of July. Then, at 111, the court begins to set out the applicant's arguments. She considered that domestic law and practice in rape cases should determine the existence or lack of consent to sexual intercourse on the basis of all relevant factors. In her view, a legal framework and practice that required proof of physical. And then if we go to 117, so that is the system complaint. Furthermore, 117, the investigation had not been thorough and complete. And if we then turn over to paragraph 124, we can see that the government argued, quite separately, in the applicant's case, the government argued after a careful and impartial investigation, the authorities had not found it established. And then, if we turn to MSP 1185, and we just look at the heading, general approach. 1185. A, the existence of a positive obligation to punish rape and to investigate rape cases. It is not. It is entirely separate and distinct.
But what did they find? Any failure of investigation other than the application of the practice of requiring evidence of resistance and so on?
In the particular circumstances, but what we see
Did they?
No, not in the particular circumstances, but what we see is that they considered the investigation quite separately.
Yep.
And so firstly, that's the first point.
Did the government take the point that this wasn't within the aspect of Article 3? Was that an argument that was raised?
I'm so sorry, I didn't hear that.
Did the government in this case the Bulgarian government raise the point that Article 3 didn't extend to this claim at all? The claim we're concentrating on. Was that a point in the case? Government's case, I think it's page 1180.
They argue at 119, the government submitted that the investigation had been thorough and effective.
Exactly.
All possible steps have been taken. They don't argue that there was no investigative obligation.
Yeah, exactly.
No.
Yep. So it wasn't an issue. That's the point I'm making. Doesn't appear to have been an issue.
So when we look at the principles that are set out from 148 to 153, we have to take it in the context that at no point is it said anywhere by anyone, including the court, that a duty to investigate only arises where there is at the same time an allegation that there is some kind of system failure, structural failure. Not said anywhere. It so happens in this case that there were the two failings that they were required to fix.
Well, what about, some sort of distinction is being drawn in paragraph 168, isn't it? Yes. Court is not concerned with allegations of errors or isolated omissions in the investigation.
Yes, so what the court is there saying is that when it comes to looking at the duty to conduct an effective investigation, which is a duty which is made clear arises, see 15152, when we come to consider what standard is required, it is simply making clear that we are not looking, an investigation will not be ineffective simply because it is subject to isolated errors and omissions.
Whether negligent or not.
I'm sorry?
Whether negligent or not.
Well, at the moment, all we have is isolated errors and omissions.
Whether negligent or not.
Yes, whether negligent or not. But what we then move on to, and we will see, that negligence can play a part in rendering an investigation ineffective if the failings, the negligent failings, were substantial, significant, and were ones which, had they not arisen, would have meant that the investigation would have been capable of identifying and dealing with the offender.
This does, to my mind, at least slightly water down your emphasis a moment ago on this being an entirely ordinary negligence approach.
No, I said, I'm so sorry.
What I
was saying, I do not for a moment, and as I said, they have imposed high standards.
The question is test effectiveness.
The test is one of effectiveness, but in asking whether or not the investigation was effective, the reasonableness of the measures that are required to be taken is the benchmark, just as it is in relation to the Osman duty. The question for the court is, were the steps that were not taken or were taken reasonable? It doesn't mean it's a straight negligence test, far from it. But the critical point here is what we have, 152 and 153, we could not have a clearer statement that firstly, the duty to investigate is not one which in principle can be limited to private persons, to state officials. And they say in terms, in principle, as a matter of principle, and one can see why, as a matter of principle, you can't limit it to private persons, because they've already identified at 149, they have already identified a principled requirement on the state to take measures designed to ensure that individuals within their jurisdiction are not subjected to ill treatment, including ill treatment administered by private individuals. Now, if that is the duty on the state, then in principle there is no reason why a duty to investigate should not also fall upon the state in relation to ill treatment by private individuals. And then at 153 we have it made absolutely clear that this is not just a duty at a structural level, it is a duty to apply the criminal law provisions effectively in practice through effective investigation and prosecution. If we then move on to, we can see at 177 a detailed consideration of the particular allegations of failings in the investigation of the applicant's case. And then, importantly, at 185 to 186, in sum, the court, without expressing an opinion on the guilt of P&A, finds the effectiveness of the investigation of the applicant's case, and in particular the approach taken by the investigator and prosecutors, fell short of the requirements inherent in the state's positive obligations. viewed in the light of the relevant modern standards in comparative international law to establish and apply effectively a criminal law system punishing all forms of rape. So they look at the investigation. As regards the government argument that the national legal system provided for the possibility of a civil action for damages against the perpetrators, the court notes that this assertion has not been substantiated. In any event, as stated above, effective protection against rape and sexual abuse requires measures of a criminal law nature, and then they refer back to their paragraphs, that's footnote 58, they refer back to paragraph 124, 148 and 153. So 123, i.e. they refer right back to the requirement to have effective investigations in practice. It's not good enough where you're dealing with deliberate ill treatment to leave it to the individual. You have to prescribe it in criminal law, and you have to make the application of that criminal law effective in practice. It couldn't, in our submission, we say, be clearer. Secic and Croatia, that is in the same volume at tab 33. This is a case where this was a group of Roma collecting scrap metal. They were attacked by two men. It was a racist attack. And if we turn to paragraphs 52 to 54.
It would help to have a page.
I'm so sorry, it's 1413.
Yep.
52 to 54, we can see that the court relies upon MC in Bulgaria, relies upon Menson, which we'll come to, an Article 2 case, positive obligation to conduct an official investigation. Such a positive obligation cannot be considered in principle to be limited solely to cases of ill treatment by state agents. Lastly, the court reiterates the scope of the obligation by the state is one of means, not results. They must have taken all reasonable steps available to them to secure the evidence concerning the incident. So there we have an indication of what the standard is that applies to render an investigation effective. And again, we see that they refer there to Menson. And there's a requirement of promptness and reasonable expedition. At 55, we see an analysis of the facts. There are no systemic issues. There is a very careful examination of the operational steps taken to investigate. A violation is found. It was a violation of purely operational failings. It was not a case concerning children, and it was not a case, in this instance, relating to women and sexual violence. Bogdanovich, that's in volume 3. And that is at tab 19, and the relevant page is 479.
Sorry, page?
It's tab 19.
Yes, page, which page are we?
I'm so sorry, it's 812.
788.
812.
Thank you. 812, thank you.
So the facts are a little bit complicated. This individual applicant was a victim of various assaults perpetrated by minors. Minors as in children. Complaint was made in 2000, and by 2006 proceedings had been discontinued. At paragraph 69, page 810, 69 to 71, compliance with the state's positive obligations. There is a reference to the need for the ill treatment to reach a certain level of seriousness. And then we get, at 70, the court observes, however, that even in the absence of any direct responsibility for the acts of a private individual under Article 3 of the Convention, state responsibility may nevertheless be engaged through the obligation imposed under Article 1 in this Convention. In this connection, the court reiterates the obligation of the high contracting parties to secure to everyone within their jurisdiction the rights and freedoms defined in the Convention. Taken together with Article 3, requires states to take effective measures designed to ensure individuals within their jurisdiction are not subjected to torture or ill treatment, inhuman and degrading treatment or punishment, including by private individuals. So we see there is the high order duty to secure the rights. That then cascades down to this particular duty, and then we see at 71 how it cascades down further. They have to put in place effective criminal law provisions to deter the commission of offences against personal integrity backed up by law enforcement machinery for the prevention, suppression and punishment of breaches of such provisions. So that's the next level down the cascade. And this requirement also extends to ill treatment by private individuals. They then say that there has to be a balance. That's what follows next. So they're recognising the need for a balance, one of the criticisms of the Secretary of State. They then look at the criminal...
It's not much of a balance, is it? It's not giving away very much to say that the state can't be expected to guarantee that no private individual will injure any others.
No. But we will see elsewhere it talks in terms of needing to provide a proper recognition of the need for balance. Now, then, if we turn to 70...
Could you read the last sentence of 71, please?
71, last sentence. In order that a state may be held responsible, it must, in the view of the court, be shown that the domestic legal system, and in particular the criminal law applicable in the circumstances of the case, fails to provide practical and effective protection. Practical and effective protection, yes. So that's looking at both the need for the criminal law system to be such that it is protecting the individual against ill treatment, but it must be practical and effective. And as we look through, we see what they mean by practical and effective protection. So at 74 to 75, they spell out precisely what is required by minimum standards. The court will now examine whether or not the impugned regulations and practices, so here we're on regulations and practices, and in particular the domestic authorities' compliance with the relevant procedural rules, as well as the manner in which the criminal law mechanisms were implemented in the instant case, were defective to the point of constituting a violation of the respondent's positive duties, obligations. 75, in respect of the duty to investigate, the minimum standards applicable, as defined by the court's case law, include requirements that the investigation be independent, impartial, and subject to public scrutiny. In addition, for an investigation to be considered effective, the authorities must have taken whatever reasonable steps they can to secure the evidence concerning the incident, including, among other things, a detailed statement concerning the allegations from the alleged victim, eyewitness testimony, forensic evidence, and, where appropriate, additional medical reports. So, investigative duty is there as one of the duties required to render the protections practical and effective. 79.
So could you read 78?
It must be stated at this juncture it is
Which
not...
one where are we going?
78.
78, thank you.
It's not the court's task to verify whether the domestic courts correctly applied domestic criminal law. What is in issue in the present proceedings is not individual criminal law liability. Yes, so that's not in issue as to whether or not this individual actually did commit the crime, but the state's responsibility under the convention. Precisely, its responsibility to conduct an effective investigation. The court must grant substantial deference to the national courts in the choice of appropriate measures, while also maintaining a certain power of review. So this is where we're talking about a fair balance and deference. They then go on to apply the minimum standards they identified in paragraph 75. And before they do that, they set out the basic rationale, as they see it, for the obligation.
They seem to say in that second sentence that they'll only review and intervene in cases of manifest disproportion between the gravity of the act and the results obtained at domestic law level. I think your case is that the European Court of Human Rights and we will, as if we were a court of first instance, review what happens and hold the state liable under the convention if there's any shortfall at all. Any failure.
Not any shortfall, no, that's the whole point. We will see the test emerging, and the test is defined in paragraph 221 of Mr. Justice Green's judgment at 226, the relevant test. That was approved in the Court of Appeal, and the defendant at no point sought to appeal against that. But we'll at the moment, we're looking at, is there an investigative obligation at all? And once we're looking at that, we will see the court explore what it comprises in terms of the standards that it imposes. At 79, in this connection, the court notes that the obligation on the state to bring to justice perpetrators of acts contrary to Article 3 serves mainly to ensure that acts of ill treatment do not remain ignored by the relevant authorities and to provide effective protection against acts of ill treatment. that critical point, that the investigative obligation provides a means by which to protect the community against ill treatment. 85 to 86, we can see its conclusions in relation to this particular complaint that the investigation was ineffective. And we can see that they do take a critical view and find that there was, in fact, a breach. Next is Vasilyev, which is in volume 5, MSP 1480, tab 36. Facts are summarised in our case. We can turn to paragraph 97, page 1497.
Yep.
Makes it absolutely clear the state is not complicit. The court observes that the applicant did not lay any blame on the authorities of the respondent state for the attack of which he and his friend were victims, nor was it suggested that the authorities knew or ought to have known that the applicant had been at risk of physical violence at the hands of third parties and failed to take appropriate measures to safeguard him against that risk. So this is not a complicity case in any way, shape or form. 98, however, the absence of any direct state responsibility for acts of violence that meet the condition of severity, such as to engage Article 3 of the Convention, does not absolve the state from all obligations under this provision. And then we have a recital of the duty to secure the rights, which is the result of looking at Article 3 together with Article 1. And then we have in paragraph 99, towards the bottom, what Article 3 does require is that the authorities conduct an effective official investigation into alleged ill treatment, even if such ill treatment has been perpetrated by private individuals, and we see MC being cited. And then at paragraph 100, even though the scope of the state's positive obligations might differ between cases where treatment contrary to Article 3 has been inflicted through the involvement of state agents and cases where violence is inflicted by private individuals, the requirements as to an official investigation are similar. So we can see a convergence here of ill treatment by state agents and ill treatment by private persons. Both require an effective investigation where the requirements are similar. And they then spell out again, as we saw in the previous case, for the investigation to be regarded as effective, the key criterion, it should in principle be capable of leading to the establishment of the facts of the case and to the identification and punishment of those responsible. It is not an obligation of result, but one of means. The authorities must have taken the reasonable steps available to them to secure the evidence concerning the incident, and we saw that in the previous case, and they set out what it is that must be done. And then at 101, turning to the facts of the instant case, the court notes that the local residents immediately informed the police that 2 men had been victims of a brutal assault, whereas the conduct of the police officers who had left the applicant without assistance will be subject to the court's examination below, and we will see there was a separate complaint below, which we will look at. He wasn't assisted. What is relevant for an assessment of the police compliance with the duty to conduct an effective investigation is that the police did not compile any report on the crime or open an inquiry into the circumstances of the assault in the days following its perpetration. So, albeit there is a separate complaint that the state failed to protect the individuals once they've been identified, the duty to conduct an effective investigation focuses upon what steps they took to investigate the crime that had just been perpetrated by private persons. It is entirely separate from and treated entirely separately by the court from any complaint relating to the state's own failings. And then we can see that they continue to examine the circumstances of the failure to investigate the alleged crime by private persons. There's an absolutely clear focus on the operational steps that were taken. There's no question that there were any system failings in training officers, or anything. It is purely a focus upon the particular operational measures that were or were not taken. Now, the appellants in their case said that this was a case in which what was in issue was a substantive failing on the part of the state. Well, as we've seen, that's not so. But as I just noted, there was a separate complaint, and this is dealt with separately, MSP 1499, alleged violation of Article 3 of the Convention on account of the police's failure to render assistance to the applicant. So they then go on at paragraph 105 to look at a completely separate complaint, which is a failure to render assistance, a failure to protect once the crime had been committed. And they set out at 105 the complaint. The applicant complained under Article 3 of the Convention that the conduct of the police officers who had denied him assistance, that conduct in and of itself amounted to inhuman and degrading treatment. So that was a breach of the substantive obligation in and of itself. They then go on to consider the merits of that complaint, and they find at 122, there has therefore been a violation of Article 3 of the Convention on account of the authorities' failure to take the requisite measures to prevent harm to the applicant's life and limb, which amounted to inhuman treatment. So that is a breach of the negative obligation. They then, at 123, go on to look at the adequacy of the investigation of that breach, because there is, under the Convention, an adjectival duty or an ancillary duty to investigate alleged or credible allegations of a substantive breach of the Convention. And so what we see at 123 all the way down to 129 is a separate analysis of the effectiveness of the investigation that should have followed into the ill treatment by the officers arising by reason of their failure to have assisted the injured applicant after he had been assaulted. So we have here, my Lord Mance, we have two investigative obligations, very different creatures, deriving from entirely separate purposes and objectives, sitting side by side and being looked at by the court in one case. That's really probably as close as we get. Then we have Milanovic and Serbia. This is in volume 4, tab 30, at paragraphs 82 to 86, MSP 1242.
Tab 30. Did you say tab 30?
Yes, tab 30, volume 4, cases Milanovic
Yes. Thank you.
and Serbia.
Thank you. And you gave
Paragraph
us-
82.
Thank you very much.
This statement about the importance of Article 3, the Court reiterates Article 3 of the Convention must be regarded as one of the most fundamental provisions of the Convention, and as enshrining core values of the democratic societies making up the Council of Europe. In contrast to the other provisions in the Convention, it is cast in absolute terms, without exception or proviso, or the possibility of derogation under Article 15. Paragraph 83, in general, actions incompatible with Article 3 of the Convention primarily incur the liability of a contracting state if they were inflicted by persons holding official position. And then we see, again, the recitation of the fact that it's not limited, the duties of the state under Article 3, to preventing the acts of ill treatment by state agents. And then we have a recognition at 84 of the difficulties of policing modern societies, unpredictability of human conduct. Not every claimed risk of ill treatment thus can entail that the authorities are required to take operational measures to prevent the risk from materialising. And they then go on at 85, the court further recalls, so that was a paragraph concerned with the Osmond duty. The court further recalls that where an individual raises an arguable claim that he has been seriously ill-treated in breach of Article 3, that provision, read in conjunction with Article 1, requires by implication there should also be an effective official investigation capable of leading to the identification and punishment of those responsible. A positive obligation of this sort cannot in principle be considered limited solely to cases of ill-treatment by state agents. The MC case is cited, and then we get the scope of the obligation. And then we get at 88 to 89 the application to the facts. Again, this is an investigation This is a complaint where it is entirely about operational failures in relation to the investigation. Paragraph 23.4 of the Secretary of State's case, it is said in our submission wrongly that in fact they were looking at systemic failings. So we see this is in reference to at paragraph 88 on page 1244. The cooperation between the police and public prosecution service also left a lot to be desired. That is the complaint which the Secretary of State said showed that there were systemic concerns that were being addressed in this case. Well, on the Secretary of State's own case now, a systemic concern such as this, even if it were systemic, would not be structural, and therefore it doesn't get him anywhere. But in any event, if we actually look at the paragraphs to which they refer, 55 and 56 above, we can see there's nothing systemic about the failings. They are entirely operational. So this is a case about operational failings, just like many of the others we have just seen.
The others, I think, up to now that you've taken us to were first section decisions, but this is a second section decision.
Yes, and the cases that are before the court they go across every single section.
This is Judge Tilkins, who was a party to the first, to MC, when she was in the second section. So that when she was in the first section, so there is a continuity.
They go across every section. They go across every single section. Every section has decided, and we've produced a file with 10 more cases, more recent cases. Those also go across every section.
Right.
The trend...
I'm suggesting it's the Baroness who is...
She's a baroness.
She's a Baroness. Yes.
No, I'm just suggesting that she remembered her own previous decisions.
She wasn't in all of them. She was just, I think, in MC in this one.
Yeah.
It goes across every section. There's
Anyway,
not much more that can be said than that.
Anyway, what's the next case you want to
The next case is CAS in Romania. This is referred to, or CAS in Romania, referred to in O'Keefe.
Yep.
That
Where have we gone to now?
at
Sorry,
volume 3, tab 21, MSP 841.
Thank you.
And if we go to paragraph 68 to 70 on page 852, we get again the recitation of the incredibly well-established principles. Absolutely nothing said here that this is because it's a child, it's limited to children. As in Vasilyev, the focus is again entirely on operational requirements of an effective investigation, not limited to putting in place structures. If one then turns to paragraphs 74 to 76, we can look at their analysis of the actual investigation. They do get down and look into what happened and what didn't happen. They are required to do that because they have to look at whether the steps were taken that need to be taken in order to establish whether or not, or need reasonably to be taken in order to establish whether or not the individual is guilty of the offence. And so we can see, for example, paragraph 74, the subparagraph, the court notes for almost 3 years, no significant investigative steps were taken after the prosecutor's first decision not to prosecute. 75, nothing in the file indicates the authorities tried to find out if somebody else could be held criminally responsible for these serious crimes, raises doubts as to the effectiveness of the proceedings, in particular in such a sensitive case involving the violent sexual abuse of a minor. Of course, that makes it more sensitive. It is not a precondition for the requirement for an effective investigation. Not said anywhere.
Then paragraph 77, they draw the distinction again with...
Isolated errors, yes.
Yes.
And that is in the context where they have set out at 70 what an effective investigation requires.
70.
At 77, for the investigation to be regarded as effective, 5 lines down, it should in principle be capable of leading to the establishment of the facts in the case and the identification and punishment of those responsible. This is not an obligation of result, but one of means. Reasonable steps available to secure the evidence concerning the incident, eyewitness testimony, forensic evidence, but not an isolated error. And again, we will look at...
if an isolated error were meant that the investigation didn't succeed when it would have done, what's the position?
but then it wouldn't be an isolated error. It might be isolated, but it would be an error which was critical in the investigation. It was a critical investigative...
So all they're saying is that irrelevant errors or omissions are irrelevant.
Exactly. Exactly. If the error is not actually part of what is the core content of what it is necessary to do in order to try and establish the facts, then that is not going to be capable of rendering the investigation ineffective. BV and Croatia, this is in volume 3, also volume 3, tab 18. This arose out of a long-running neighbour dispute. If we turn to 149 to 151, at page 782.
Yeah.
Regarding the protection of the physical and psychological integrity of the individual from other persons, the court has previously held that the authority's positive obligations in some cases under Article 2 and 3 may include a duty to maintain and apply in practice an adequate legal framework protecting against violence by private individuals, more specifically in the context of serious acts of violence under Articles 3 and 8, then the Convention requires, this is at 150, putting in place effective criminal law provisions to deter the commission of offences against personal integrity backed up by law enforcement machinery for the prevention, suppression and punishment of such breaches of such provisions. And then we can see 151, from that we then derive the duty to investigate. Furthermore, the court reiterates the state's positive obligations concerning allegations of serious acts of violence by parties under 3 and 8, imply the authority's duty to apply criminal law mechanisms of effective investigation and prosecution. Criminal law mechanisms of effective investigation and prosecution. Totally different to the adjectival duty, which is about looking at whether or not there's been a substantive breach, which may have nothing to do with criminal liability.
Can you just give, don't go to it, you haven't got time, just what's the paragraph number for the serious acts of violence and their effects?
Sorry?
Yes, where is the conduct?
In this case?
Yes. Don't worry, if you haven't got it, I'll find it later. Don't worry.
No, I'm afraid I don't
Right.
have it. I really haven't focused on the test is, does it cross the Article 3 threshold?
Well, I know it is.
And that is...
I'm asking the question.
Well, I haven't addressed that because it wasn't a matter that was an issue between the parties. But there is much guidance on the part of the court. And
Well, at some stage, Ms. Kaufman, if we're going to address the principle, we're going to have to see which kind of cases it applies to. That's the only reason for the question.
Yes. So 152 and 153, they do make the critical point here. The ill treatment must attain a minimum level of severity. And they say the sorts of things that have to be taken into account. The assessment of this level depends on all the circumstances of this case, factors such as the nature and context of the treatment, the manner, method of its execution, its duration, its physical and mental effects, and in some instances, the sex, age, and state of health of the victim. Similarly, the particular treatment complained of must be sufficiently serious so as to entail adverse effects for an applicant's physical or moral integrity falling within the scope of the prohibition. And then they cite, helpfully, some cases at 153 of precisely what sorts of acts have been found to cross the threshold. So perhaps, my lord, this is actually a good place to look.
Thank you.
As good a place as any where they do actually cite that. Then at 159, they look at the incidents and they conclude, importantly here, so they are, in this case, they are confronted with a series of allegations of things that had happened, ill treatment to which the individuals had been subjected, and they, having examined them, they conclude that only in one case was the ill treatment of sufficient severity to cross the threshold. In view of its case law, the court considers that only the injuries sustained by the second applicant on the 15th of June 2011 were sufficiently serious to trigger the authority's positive obligations. It also considers, in view of the nature of the applicant's conflicts with their neighbours, that this is the only incident giving rise to an Article 8 duty. And then it considers the effectiveness of the investigation of that one incident, the only one where the investigative obligation is triggered, 160 to 161, and then it is, and this is a passage to which the court was taken yesterday, at 162, the court then says, with regard to the remainder of the applicant's allegations, and in view of its finding, that is, that the threshold wasn't crossed, the court notes there is no dispute between the parties that the applicants had the possibility of filing a claim before the civil court seeking compensation for the alleged damage and abuse, and that was particularly true, given the substantial obstacle, etc., etc. But the critical point here is those allegations were not ones in respect of which the criminal investigative obligation was triggered, and hence it's perfectly sufficient in that instance that they have available to them a civil claim against the perpetrators, because the state is not obliged, unless that threshold is crossed, to conduct such an investigation. Now, O'Keefe, the one grand chamber decision that we that there has been, that is at volume 4, tab 31, MSP 1252. Thank you. If we can go to paragraph 143. Now, what's slightly complicated in this case is the events took place in 1973, and so one of the functions of the court is to ask itself what were the nature of the duties which were imposed under the convention, which is a living instrument, on the state back in 1973. So part of its task is to go through looking at its own case law to see when positive obligations were first identified, and looking to international treaty obligations and looking at when they came into effect and see what obligations they imposed in order to get to the point of identifying what was the state under a duty to do back in 1973. Also, in this case, we are dealing with a number of different positive obligations. So what wasn't in issue in this case was the Osman duty. The court found quite clearly that there was no breach of the Osman duty because the state was not on notice back in 1973 when the applicant was the victim of the offending. The state was not on notice that she was at real and immediate risk. But there was a second question that the court has to ask itself, which was quite apart from that Osman protective obligation. Was the state under any other obligation to protect by putting in place some kind of structure or system to try and detect ill treatment that might be going on, sexual abuse that might be going on in the schools? And that's what the first part of the case is focused on. Then quite separately from that, it then looks at the question of whether or not there was a breach of the duty on the state to conduct a criminal investigation. That is, in my submission, how this case falls to be read. And we also submit that there is nothing in this case that ties it to the fact that it concerned a child, such that there is somehow some special and exclusive duty to investigate in a practical way, taking operational measures where one is dealing with a child, but not where any other person is subjected to ill treatment crossing the Article 3 threshold. So in summary, that is what we say this case decides. And that becomes clear if the court reads 144 down through to 148.
I looked at some of this before, yeah.
Yes, and you've looked at it. So really, I'm summarising here what my submissions are. I haven't really got time to take the court to it. I would ask the court to note there is repeated reference to the Article 3 ill treatment cases, Bogdanovich, footnote 46 on page 1285, MC in Bulgaria, cases that have nothing whatsoever to do with a situation in which the court has said this is because we are dealing with a child.
Well, the court in 145 and 146 does make quite a lot of the fact that it's a primary education and child, doesn't it?
Yes, and this is in deriving, over and above the Osman duty, the duty also to take other steps to protect. It has nothing to do with identifying the investigative obligation. At no stage is that a necessary prerequisite for the identification of the, that obligation. In fact, the first time it turns to the investigative obligation is at paragraph 170, and that is at page 1290, and we have alleged violation of the procedural aspect of Article 3. The applicant argued that the state had also failed to properly investigate or provide an appropriate judicial response to an arguable case of ill treatment. And her complaint is then set out. And at 172, the court says the court recalls the principles outlined in CAS and Romania to the effect that Article 3 requires the authorities to conduct an effective official investigation into the alleged ill treatment inflicted by private individuals, which investigation should in principle be capable of leading to the establishment of the facts of the case, the identification and punishment of those responsible. So we see an entirely discrete basis upon which the investigative obligation is identified, quite separate from its exploration as to whether there was a different protective duty over and above the Osman duty. And they rely on CAS and Romania, which we know is well down the path of the settled jurisprudence in this area, and they simply apply it and approve it. And in our submission, it is abundantly clear that this is a principle that is well established, has now been endorsed by the Grand Chamber, and is endorsed across the board for any ill treatment by a private person which is deliberate and therefore requires to be criminalised, irrespective of whether the victim is a child, an adult, a member of a particular ethnic group, although, of course, where there are those particular vulnerabilities, that may have implications for the task of the investigating officers. Cocky, I would simply say, Cocky is a case at volume 4, 26 in the same volume. I would ask the court to note, this is section 4, page 1111. Yes. If one turns over to 1112, yesterday Mr. Panic noted that Sir Nicholas Bratzer was involved in the Al-Masri case. Well, Sir Nicholas Bratzer was also sitting on the case of Cocky.
Yep.
And he, the relevant paragraphs are 211 to 215, where the principles are set out, standard recitation, made very clear at 213 that the duty arises in relation to acts of private persons, and nothing to indicate in this case any limitation on the duty to investigate as suggested by the Secretary of State or the appellant. Now, as I indicated, there have been many more cases since. The court should have a bundle of authorities and a table at the front of that bundle of authorities which contains, by way of example, 10 more cases since 2015. They are, as I indicated, cases taken from every section of the court, and it is yet more of the same.
Can you identify the bundle? Has it got a number?
I'm sorry, it's the, yes, my Lord Kerr has the
black
bundle.
file.
It's a black file, I'm sorry,
okay.
yes.
And it would quite help me, at any rate, if you would identify in due course in writing the paragraph numbers you rely on in these 12 cases.
They are actually in there.
They're in there, are they?
Oh, no, on the table at the front, my Lord. Yeah. If you close the file,
I beg your pardon.
There's a table. Now, all the relevant paragraph numbers are identified there, and we identify what is held in very summary form.
Thank you very much indeed. Does that represent a convenient moment then?
I'm sorry?
Does that represent a convenient moment?
That does, my Lord, yes.
Excellent. Okay, we'll resume again at 2 o'clock. Thank you very much. Court will now adjourn.